patent sucks. There is no such thing as an international patent. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. There is a belief out there that you can file an international patent or get an international patent that covers the entire world, and that belief is false. Patents are territorial. Each country has its own patents. Some countries have formed groups, like in the European Union. They have the European Patent Convention, where you can get a patent that covers the region in some cases. But the bottom line is you need to get a patent in any country or region in which you want to exclude others from practicing your invention. You cannot take your U.S. patent to England and go to court with it. You can't take it to China. You can't take it to Japan. You can only assert a U.S. patent in the United States. And the converse works for all those other countries. Now, the confusion with the international patent thing comes along because there is a thing called an international patent application, and it's called a Patent Cooperation Treaty, or PCT application. And they publish these documents. I'm going to show you one in a minute. And so when you look at a PCT application, if you're not familiar with what you're looking at, it does look like a patent and it looks like an international patent, but that's just an application. Ultimately, that application has to be processed and entered into what they call the national phase anywhere you want to actually get a patent. So ultimately, that application ends up being prosecuted in whatever patent offices are in whatever countries you want to get a patent in. But that thing itself, the PCT application, never itself becomes a patent. So let's take a look so you know how to recognize what a PCT application looks like. So this is a Patent Cooperation Treaty, or PCT application. You can see at the very top it says International Application published under the Patent Cooperation Treaty, PCT. The PCT is administered by the World Intellectual Property Organization, or WIPO, which has a website at wipo.net. So every PCT application has two key identifiers associated with it. The first is in the upper right-hand corner underneath the barcode. It's the International Publication Number, which is WO2022/006213A1. The other key identifying number is the application number. Now, for that one, you have to go in the left-hand column where it says parentheses 21. You'll see International Application Number. And it's PCT/US 2021/039785. So this is not a patent. It is a published version of an international patent application, but it does look like a patent. In a PCT application, unlike a U.S. patent application, the drawings do not come after the face page. Instead, it goes right into the specification, which you can see here. This is one I wrote myself a number of years ago. And the basic structure of it is the same as a U.S. patent, but then you get down to the claims at the end. There are the claims. And then, unlike a U.S. patent or patent application, the drawings are at the end. They're after the claims. So you see here, there's 31 sheets of drawing. That's the first sheet, etc. So that's what a PCT application looks like. So when you're filing a PCT application, you can file it as your first filing in the United States if you want, as long as you use the USPTO as your receiving office. You don't have to file a U.S. patent application first, because a PCT application filed in the United States is treated as a U.S. patent application filed in the United States. It's treated the exact same way. And I have had clients that make that their initial filing, a PCT application. You can do that. And what happens is with a PCT is that within 30 months after your priority date, which will be either the PCT filing date or any earlier application it claims priority from, within that 30-month period, you have to enter the national phase. So, like, for example, if you had a PCT that you filed in the United States, then within 2.5 years, you'd have to enter it into the national phase in the United States if you want to get a U.S. patent. Of course, you also have to enter it into the European national phase, they call it a regional phase in Europe because it's a region, or the Japanese national phase, wherever you want to get a patent. But you have 30 months. And then in that 30-month period, the PCT authority will do a search and give you a written opinion that's non-binding on any of the patent offices, but it will give you an idea using generally applicable principles of patent law that are generally applicable worldwide about whether your invention is likely to be patentable. And one benefit of that is that you can see that report and then say, you know what, I don't want to spend all the money going to these foreign patent offices because I don't like my chances. So it's definitely helpful in that regard. But like I said, by itself, it never becomes a patent. So anyway, that's what the deal is with international patents. There's an international patent application, no international patent. If you want a patent in a foreign country, you got to get the patent in that foreign country. I hope that helps to keep you out of trouble, and I hope to see you here soon.